and welcome. Well, after the Supreme Court's landmark verdict on the right to privacy, India is now moving towards a legislation on data protection. The Justice B.N. Shri Krishna Committee today released a white paper inviting suggestions on the recommendations made on a draft data protection framework. The 200-page plus document studies various data protection laws across the globe and suggests norms relating to data collection and penalties for misuse of user data. The deadline for sending feedback is December 31st, 2017. So just to discuss this further, we're actually joined by Pranesh, Prakash of the set, Rahul, Matthan, of course, the partner at Trilegal. Rahul, thanks so much for joining us. And we also have Pranesh Prakash, Policy Director at the Center for Internet and Society. Guys, thanks so much for joining us. Mr. Matthan, I'd like to start by asking you, when you went through this 240-page white paper, what were your initial thoughts? Is this something that has been well thought out, and it perhaps covers the intricacies of a data protection framework that's required?
Well, I mean, it's 240 pages, so it's difficult for anyone to go through that in the short time since it was released. But I have skimmed through it, and just from a brief perusal, it seems extremely detailed. It seems like they've covered many of the topics that I would expect to find in a data protection law. And I think it's, from my perspective, it's good that they are doing this through a consultation process. We find this quite rarely in the legislative process in this country, that this level of consultation is invited. And I hope that Justice Sri Krishna and the rest of the committee keeps up this approach and genuinely considers the feedback from all the various people who I'm sure will write in with their comments and suggestions.
Right, Pranesh, what Mr. Matthan was saying is kind of interesting because of course, it's a 240-page document. I've been trying to go through it all day, like you guys as well. But what I'm trying to understand from you as well, Pranesh, is that there are several questions that have been raised. And what's most interesting about this is that it's a consultation paper. So just like it was on net neutrality, on the OTT platforms issue, well, we can actually write in and perhaps engage in this sort of dialogue. But what I wanted to understand from you, Pranesh, is there's a lot in the paper in terms of principles, technology, agnosticism, holistic application, informed consent, data minimization, controller accountability, structured enforcement, and of course penalties which will serve as deterrents. It's covered quite a few interesting topics. We can't cover all of them because it'll take hours to cover them. But what were some of those key themes that stood out for you?
Let me first just echo what Rahul just said, which is I quite like the approach of the paper. Given its mandate, they've done quite a good job of providing background and asking not just several, but from someone who counted 229 questions, it seems. So it's a very, very detailed paper. And lays out very good ground and raises pertinent questions, etc. In terms of themes, of course, it covers everything that one would expect from such a paper, and it covers pretty much all of what is there in the new general data protection regulations that are coming up in the European Union, which it covers in quite some amount of detail. But a few things that stood out for me were things that were not just legal, but things that really fall into the realm of political economy. One thing I would have liked to see a little bit more of would have been some kind of political, realpolitik analysis of where data protection is going globally, given that the EU is emerging as a global superpower when it comes to data protection and its stringent requirements. And so, and it requires that its trading partners who handle European Union citizen data, resident data, actually follow those rules as well. What kind of implication that has on what we in India can set up. These kinds of considerations, which are not just jumping into the nitty gritties of the law and questions about how would jurisdiction apply, etc., but really are questions of political economy, uh, unfortunately have not been addressed, and that's something that I wish would be rectified. There are a few other things that I wish to raise as well, including questions about enforcement and co-regulation, but perhaps I'll keep that for later.
Pranesh, and that's and there's something that I do want to talk about, and I'd love to get Mr. Matthan's view on it as well, is essentially, well, there is a sort of a mention of Aadhaar, of course, considering that this white paper does stem from the whole debate surrounding Aadhaar. Now, considering, Mr. Matthan, that, well, the Supreme Court has ruled on privacy and it being a fundamental right, and also, well, they've actually recognized that it's largely informational privacy is what we're talking about when we talk about data protection. When it comes to Aadhaar, and a little bit that has been mentioned, well, data protection norms for personal information collected under the Aadhaar Act are also found in the Aadhaar Data Security Regulations 2016. They impose an obligation on the UIDAI to have a security policy which sets out the technical and organizational measures which will be adopted by it to keep information secure. But they also go on to say, Mr. Matthan, that despite its attempt to incorporate various data protection principles, Aadhaar has come under considerable public criticism. First, though, seemingly voluntary possession of Aadhaar has become mandatory in practice and has been viewed by many as coercive collection of personal data by the state. So I think the paper does acknowledge the concerns that Indians really have with Aadhaar. But do you think it, perhaps, if this was something that was incorporated in the data protection framework, it would be usually beneficial and perhaps bust some of those myths?
So, I think where you're reading from is the preamble, the preamble section, where the committee goes into some detail on the background, how we got here, discussions around big data and things like that. In the meat of the white paper, they don't really get into the specifics of Aadhaar. I think the approach, and I quite agree with this approach, is to prepare a overarching privacy law that would apply to the state as well as to non-state actors. And quite frankly, this is what has been pointed out in the Puttaswamy judgment. Even though in that judgment they refer to the fact that non-state actors would eventually be governed by a law, and that is in fact the law that we're discussing in the context of Justice Sri Krishna Committee. And I think that this overarching legislation would encompass within it various obligations that people who use Aadhaar would need to comply with, as well as people who don't use Aadhaar but for other circumstances and other ways capture personal information, sensitive personal information. They even have a section on information related to children. And so, in that sense, this is a much broader regulation, a much broader framework than something that would only apply to Aadhaar. I think just taking off from what Pranesh just said, the one concern that I have is that in many ways the framework seems to have been lifted or is very heavily dependent on the framework articulated by the GDPR. And if the privacy law is to apply equally to government as well as to private parties, then the GDPR is perhaps not the best playbook to copy from. The GDPR tends not to focus as heavily on regulating government. But as you go through the various questions and the various provisional recommendations that they have, there does seem to be a reference to both state and non-state actors, and I hope in more detailed perusal of the white paper that I'll be able to see some of those details and be able to comment a bit more on sorts of nuances. whether this was going to be for both, going to apply to both government as well as non-government actors.
Mr. Matthan, it's kind of interesting because there's one more thing in the white paper, and it seems quite interesting and modern in terms of its take, because there's this whole section which I was reading on the right to be forgotten, which is interesting because, I've spoken to you about this at length before, but, at a time when Europeans have actually gone to court against Google to extend the scope of the right to be forgotten beyond Europe as well, it raises a lot of questions about the scope and the extraterritorial application of a law like this. If something like that was to be considered here, I know it's very nuanced and it's perhaps a very evolved concept, but it's interesting that even a scenario like that has been considered in India for a modern data protection law.
But that's the good thing about the white paper. I think they've gone to some lengths to discuss all sorts of issues that are currently facing privacy professionals around the world. The right to be forgotten certainly is one such issue that gained a lot of prominence a couple of years ago. The jury is still out as to whether it is a good right to include or not. I think from the US perspective, and also just from the perspective of people who are actually having to implement the right to be forgotten, it's not that easy to implement. And so I think we should be a little cautious with choosing to adopt those principles. But I think leave aside the specificity of that particular point. I think it's an indication of the extent to which the committee has gone to explore various modern concepts of data protection. I think they spent some time on algorithmic decision making, and they seem to have touched on the principle of accountability. These are all new concepts that I'm quite keen that the committee explores in some detail. And I think if there's one message I would have for the committee, it is that they take the effort to craft a law that is appropriate both for our country as well as for the times that we are in, and not just blindly copy a law that some other country has drafted without seeing how it applies to India. And as Pranesh says, also to our place among all the nations of the world, so that we don't isolate ourselves because of impractical data restrictions or things like data localization, which would make it difficult for people to do business in India.
No, absolutely, Mr. Matthan. Pranesh, something I wanted to ask you as well is it's about scope. Since we were talking about scope, a different way to look at it is that this has been a debate raging on privacy for the past 2 or 3 years. I think since 2015, we've been talking about it. Now that we have some clarity on it being an implicit fundamental right, what I want to understand from you is, essentially, if you look at what a data protection framework is all about and what we're talking about in this situation, it seems like the focus is shifted to data protection per se, which is one aspect of privacy, right, as informational privacy. There's a lot more to be discussed when it comes to privacy per se.
Absolutely. And so this is the one bit where I had an issue with what Rahul had stated, because I don't see this as laying down a privacy framework per se for India, or this exercise being about that really. Just to take one example, when they talk about national security as an exception as a potential exception for data protection regulations, they talk about accountability, but it's a bit strange to be talking about accountability in the name of national security when the intelligence agencies in India are not accountable to Parliament. So one can't just bring about accountability of the government vis-a-vis surveillance and surveillance powers just with respect to data protection. One needs much more. And so even when it comes to informational privacy, data protection is one part of that, but it's not the whole of that. So, and this isn't to criticize the committee itself, because this was the mandate provided to the committee to explore data protection, and it was not to explore privacy more generally And I believe it would be quite welcome for the government to actually move forward on other aspects of privacy as well, including regulation of surveillance of intelligence agencies, etc.
Right,
And
Pranesh.
if I may just add one other bit,
Of course.
uh, we may have the best of laws, we may frame fantastic regulation, but they won't really be worth much if they can't really be enforced. And it is here that we must look at how models like co-regulation really work. And for co-regulation, which means that it's neither just top-down governmental regulation, nor completely bottom-up self-regulation of various sectors, but somewhere in the middle. And there are various different models of co-regulation that scholars have written about over the years. For that to really work, it can't just come at the level of enforcement as the paper has slotted it, but it has to come at the level of policy formulation,
Right.
at the level of looking at how well it is working, as well as at the level of enforcement. So that's something that must be taken seriously. The Justice A.P. Shah group of experts in privacy of 2012 also recommends co-regulation, and I hope enforcement and co-regulation are also considered more seriously by the committee.
Right, Pranesh. And since it's up for debate and it's a consultation paper, Mr. Matthan, there's something I want to ask you. There's a paper authored by you in July. It's called Beyond Consent, a New Paradigm for Data Protection. It's an interesting piece because you talk about how a rights-based model can substitute a consent model. Now, if you could explain to all of us how a rights model might work well when it comes to data protection for countries like India.
So the model essentially says, it explores the concept of consent in the modern context, and it comes to the conclusion that the use of consent in the context of a lot of the modern uses of technology make it actually quite difficult to provide informed consent, and so the approach behind the paper was to try and find some alternative to consent. The alternative actually is accountability, and the way that is supported is by articulating a set of rights that every individual has, that you have regardless of whether you've entered into a contract consenting to have your data collected or not. And if those rights are violated and if any harm is caused to you, the person who causes that harm is accountable for that harm. Now, as a position paper, that the document was exploring a sort of an extreme solution to the problem with consent. And I think, quite realistically, I acknowledge that it is probably impossible to do away with consent, given how closely wedded consent is to the whole notion of personal privacy. It has been for many years. And I think an appropriate solution would be to have some form of consent, but not have consent come in the way of holding data controllers accountable for the harms they cause. And I hope that the committee does consider these sorts of solutions as well. These are not completely new solutions. These are concepts that have been discussed. In fact, accountability finds place in the proposed EU GDPR as well. So it wouldn't be beyond the pale for the Indian government to consider these sorts of approaches in formulating the privacy regulation. But the idea really is to try and find some way in which to make consent better. The way it currently operates, it's actually quite difficult for anyone to fully understand what they have given their consent for, and what the implications of having given that consent are.
Interesting, Mr. Matthan. Pranesh, there's another thing I want to ask you. And we can go on talking at length about this because there's so many provisions out there. But there's one interesting provision just to talk about well, how elaborate this paper really is, because it goes on, talking extensively on the definition of personal information or data, and also on which of those terms should be used in the first place. In the EU, it's used differently. In the US, it's different. And also, it's interesting because it also talks about a new category which would require much higher expectation of privacy, being sensitive personal data, financial information, health information, caste, religion, sexual orientation, stuff like that. Do you think that these are things, considering what Mr. Matthan was saying, we're living in this increasingly globalized, interconnected world where servers and hosts are on one end, users all over, there's exchange of information all over the world. Do you think this becomes imperative?
Well, it depends on what this is. So just a quick point, though, first, that the kinds of criticisms that Rahul has raised in his position paper are also echoed in the white paper, and from the little that I managed to read of it, given the paucity of time. So Rahul should be pleased today. And in terms of the difficult questions of what really are we talking about when we're talking about data protection, the paper does quite a good job of laying out the field. There's the question, of course, of whether data protection should be concerned only with individuals and or whether it should be concerned about rights of citizens, which is a different category from individuals, which can be any kind of resident or natural person, or whether it should also include legal juristic persons such as corporations. These are actually not easy questions to answer, but they've done a good job, I feel, of laying out that field, and their initial sense in this seems reasonable, except there seem to be some contradictions in terms of what their provisional positions, as they termed them, are. So of course, this is a white paper, and I am cognizant of that, so I don't want to be overly critical. But while they do a great job in terms of laying out the field and the complexity of the problem, the provisional positions really don't do justice to the discussion that they actually start off with. So does that answer the question, or there's something I missed out?
Go on talking about this, but guys, thanks so much for joining us. It's been a fascinating chat, and well, let's all hope that we can, all send in our recommendations for this paper as well. Well, moving on, expect India to grow at 8% in 2019. That's the word coming in from Chief Asia Economist at Goldman Sachs, Andrew Tilton. My colleague Pradeep Pandya had the chance to speak to him about the latest report he's co-authored, and started off by asking him about what's fueling the optimism on India.
Two reasons. The first is we think the shocks that the economy has endured over the past year, the impact from demonetization and the GST reform, we think will fade out over the coming year, so less of a drag on growth. And then we do think the initiative to recapitalize public sector banks should be helpful in terms of easing credit conditions and boosting growth towards the end of the calendar year 2018.
Well, these recent reforms have actually been taken positively by most experts. But how do you really see the divergence between the views of two leading rating agencies when it comes to Indian macros?
Well, I think most investors really, and clearly those from the equity side, but even to some extent from the fixed income side, they're looking at the broad growth, inflation, rate reform outlook. I don't think in the short term their decisions are driven dramatically by rating agencies' changes. Of course, those factor into the decisions, but I think the bigger driver of markets in 2018 will be: do we see the pickup in growth? I think it's likely we see a pickup. The question is how rapidly does that occur? Where does inflation go? I think it's pretty likely that'll move higher, partly because of global factors, partly for reasons of higher food inflation and other factors. And then how does RBI react to that? Are they comfortable at current rate levels, or will they feel the need to adjust as we go later in 2018?
We'll come to some of those points, once again. But do you think it's a matter of time before the S&P or other rating agency, the third rating agency, also kind of thinks of an upgrade?
We don't really try to predict rating agency decisions, so I don't have a view on whether they'll upgrade or not, frankly.
No, but actually, what is your medium-term outlook on India? Do you think, the kind of reforms we have undertaken have had a negative impact on growth, really? So there is a slowdown. Now you think the growth is coming back. Will that growth come back with stability, without compromising on, the fiscal path that we have in mind, and a very robust macroeconomic, or rather the monetary policy framework that we have in place for the first time in Indian history? If these things remain intact, then it's not only the short term, but a medium to long term outlook should also be very strong. So I want your view, with that perspective. Not really. I want you to predict what rating agency will do next.
Yeah, well, I think you're absolutely right. The shift in, for example, the RBI monetary policy regime, the efforts to implement things like the GST, which should facilitate more efficiency nationwide. I think these are clearly things that should boost potential output and growth. The question is the timing of that, more than whether it will happen. So I think you can see that, broadly speaking, investors are optimistic on this. You still have foreign equity investors overweight on Indian equities relative to their benchmarks, which suggests that they share some of the optimism about the reform agenda. The question is, and this is often the case with reforms, some short-term pain for longer-term gain. How much disruption is there in the short term, and when do you begin to see those benefits of the reforms? And that depends to a large extent on the efficacy of implementation and the staggering of the different reforms and the global backdrop, which we think will be pretty favorable in 2018.
So when the economy is going through such a transition process, you expect the fiscal and monetary policy to kind of support, and they have been actually supporting. But if you look at the outlook, which has come from Goldman Sachs, is again, way ahead of consensus. And while other experts are still looking at a rate cut, you are actually calling for 3 rate hikes over next 18 months or so. Why do you really think it would be possible for RBI to do that?
Our rate model is based on really the so-called output gap, where we think capacity utilization is relative to its equilibrium level. So we think that'll be improving over the next year. The inflation outlook relative to the RBI's target, we think inflation will move from the lower part of the target band, so below 4%, to the upper part of the target band over the coming year, to around 5 or a bit higher.